Hello, my name is Maria Popova, here on behalf of Broken Chalk, and today I'm joined by Mr. Hakan Kaplankaya. Hello, it's very nice to meet you.
Nice to meet you. Thank you for having me. Thank
Of
you,
course.
Maria.
Today we're going to discuss the decision of the Court of Human Rights on Yuksel Yalcinkaya versus Turkey. So can you elaborate for us what is the decision about and what is its importance?
Okay, thank you, Maria. The Turkish government launched a crackdown on the Gulen movement, especially after the graft probes in December 2013, which escalated to an annihilation campaign after the failed coup occurred on 15 July 2016. And the Gulen movement was designated as a terrorist organization after that, which paved the way to widespread criminal prosecutions for membership in a terrorist group against the members and followers and sympathizers of the movement. Within criminal proceedings, routine activities were treated as evidence of terrorist organization membership, such as subscribing to a daily, enrolling children in Gulen Movement affiliated schools, education centers, depositing money in Bankasya, using the ByLock application, joining Gulen Movement related associations, and participating in religious talks. Over 600,000 people were prosecuted, with more than 300,000 detained and over 100 convicted on terrorism charges. The European Court's judgment is a long-awaited response to this travesty of justice. Another notable aspect of these prosecutions and this judgment is that the Turkish judicial practice has risen to the level of crimes against humanity. As fellows of Institute for Diplomacy and Economy, we drafted a report on this issue 2 years ago. In various opinions, the UN Working Group on Arbitrary Detention has concluded that the arbitrary detentions faced by numerous Turkish individuals linked to the Gulen movement, to this group, since the coup attempt, follow a systematic and widespread pattern, possibly amounting to crimes against humanity. Hence, the international community should give due consideration and examination to this dimension. Thank you.
Yeah, perfect. We know that the judgment in the case highlighted violations of Article 7, no punishment without law, and Article 6, Paragraph 1, which is the right to fair trial. Could you explain how the court found that the applicant's conviction, based on the use of the ByLock application, departed from the actual requirements under national law and also was contrary to the object and purpose of Article 7? Because this article aims to provide safeguards against arbitrary prosecution.
Yeah. The court observed that the applicant's conviction for membership in a terrorist organization was primarily based on his alleged use of ByLock messaging application, while other evidence, such as his account at Bankasya and his membership in a trade union and his membership in an association, served as corroborative sources. The mere use of ByLock application, regardless of the content of the messages or the identities of the recipients, was deemed sufficient in domestic law, in domestic practice, to establish all the elements of the crime of belonging to an armed terrorist organization. The court acknowledged that the use of ByLock could indicate some kind of connection with the Gulen movement, but disagreed the domestic court's conclusion, which was mere downloading and the use of the application, pointed out to the full submission to the organization and its hierarchy. Instead, the court found that the reliance on the mere use of ByLock alone to establish the elements of this offense was an unforeseeable and expensive interpretation of anti-terror legislation. This interpretation essentially created an almost automatic presumption of guilt based on solely use of ByLock, making it extremely difficult for the applicant to prove his innocence. Without examining the presence of knowledge and intent, which are requirements in legal definition of the offense under domestic law, the court observed that objective liability was effectively attached to the use of ByLock. This interpretation by domestic courts effectively bypassed the essential, particularly mental element of the offense, and treated it as it were a strict liability offense, thus deviating from the clearly established requirements, clearly established case law in the domestic law. Consequently, the court ruled that there had been a violation of Article 7 of the Convention.
Yeah, thank you. We also know that in the judgment, it was identified that there are certain procedural shortcomings in the criminal proceedings against Mr. Yalcinkaya, particularly when it comes to his ability to effectively challenge the ByLock evidence, so which essentially breached his right to fair trial. Can you elaborate on the specific failures in the court's handling of the ByLock evidence? And of course, also how these shortcomings undermine the applicant's opportunity to challenge the evidence effectively.
Regarding Article 6, Paragraph 1 of the Convention, the court examined whether the applicant, who faced non-disclosure of crucial ByLock data, was given adequate procedural safeguards, and whether the applicant was afforded a suitable opportunity to prepare his defense. The court criticized the silence of the domestic courts concerning the rejection of the applicant's request for ByLock raw data, as well as the applicant's substantiated concerns about the reliability of the evidence. The refusal of applicant's request to independently examine the raw data for verification of its content and integrity was also noted by the court. The court emphasized that the proceedings should have allowed the applicant to comment on the decrypted material fully, ensuring a fair balance between the parties, between the prosecution and the defense. In conclusion, the court found insufficient safeguards for the applicant to challenge the evidence effectively and on equal footing with the prosecution. The failure of domestic courts to address the applicant's requests and objections raised legitimate doubts, that they were impervious to the defense arguments. The court ruled that, it's important, the applicant was not genuinely hurt, concluding that the criminal proceedings fell short of a fair trial that breached the Article 6, Paragraph 1 of the Convention.
Yes. And also the court held that Turkey must take general measures to address systemic problems, especially when it comes to the Turkish judiciary's approach to the use of ByLock. So as a legal expert, what specific measures do you believe would be necessary to rectify the identified problems and ensure that future cases which involve digital evidence would comply with the requirements of the ECHR?
Yep, thank you. The court highlighted that the systematic nature of this issue, with over 8,000 similar cases and potential for around 100,000 more cases from Turkey, which would be reached to the court. To address this, Turkey needs to implement general measures for its resolution. Although the anti-terror legislation has faced criticism for its broad interpretative potential, mainly from scholars, the Venice Commission, and even in some judgments of the European Court, I believe the core problem lies in the arbitrary interpretation by the Turkish judiciary, rather than the legislation's wording. Despite Yalcinkaya reflecting the court's stance on this interpretation, there is still room for a legislative amendment, which may make the legislation more clear and more clarified. However, the most immediate solution would be a case law change, a jurisprudential change, with the Turkish judiciary aligning itself with the Yalcinkaya judgment. refraining from incriminating people for ordinary, regular activities, non-criminal activities. Unfortunately, 4 months after the release of this judgment, the Turkish courts have not given a clear signal that they have aligned with it. Reopening of the cases is on maybe another center of discussion. Reopening cases in Turkey that have already been presented to the European Court could present a viable solution. All the Turkish criminal procedure permits the reopening of a case if the European Court identifies a violation. This right is currently not extended to similar cases. Nevertheless, a recent ruling by the Turkish Constitutional Court lends support to this potential solution. Consequently, a legal amendment to explicitly address and clarify this issue would be beneficial. But unfortunately, I'm not aware of any instance, any judicial authority, a domestic court has approved the reopening of a case which is similar with Yalcinkaya. And until now, we don't see any clear signal from the Turkish judiciary to accept the reopening request from the applicants whose cases are similar with Yalcinkaya. Following the Yalcinkaya case, individuals convicted of terrorism charges based on their alleged membership in the Gülen movement should be acquitted. The ByLock evidence, riddled with numerous shortcomings, was examined by the Strasbourg court, which criticized the Turkish court's flawed examination without explicitly affirming its evidentiary value. However, given the significant deficiencies in the ByLock evidence, it becomes untenable for any impartial court, any impartial tribunal to accept it as credible. Moreover, the court identified a more substantial issue, emphasizing a violation of Article 7. Hence, after the Yalcinkaya case, all people who have been faced with these types of prosecutions, people should be the result should be clearly and acquitted.
Of course. And as you mentioned, there are over 8,000 pending cases of similar nature. And we know that there's potential for over 100,000 other cases based on ByLock usage.
Yeah.
So you mentioned that the Turkish authorities have not given any indication, to actually fall in line with the decision of the court. So how do you think that their non-compliance with the Yalcinkaya decision could impact not only Turkish judicial system, but also its international standing? And what steps, like short steps, could the authorities, especially the Constitutional Court, take to address the issue promptly?
In fact, it was stated in the judgment. It's binding on the Turkish judiciary. There is no discussion on this.
Yeah.
Therefore, the Turkish Constitutional Court and other superior courts, just as such as Court of Cassation, should align with it. Failure to do so may result in the European Court issuing violent judgments for similar cases and potential future applications. So there is much more. The court said that there will be more potential 100 cases. So there will be always violations.
Yeah.
The Committee of Ministers of the Council of Europe will monitor the execution of this judgment. So this procedure is a political and diplomatic process. Importantly, according to the the Turkish Constitution, the judgments of the European Court is binding. So there's no discussion. And I hope that this judgment, all judgments of the European Court of Human Rights, eventually will be implemented in Turkey by Turkish authorities. So we'll see.
Yeah, hopefully. It's good. So we also know that this is a very this judgment has a historical significance, especially when it comes to its impact on Article 7 violations. We know that the ECHR has been reluctant or cautious to find such violations of Article 7 over the years. So could you elaborate on the specific legal principles that are related to Article 7 and to the legality of crimes and punishments? What makes Article 7 violations so severe?
In fact, the principle of no punishment without law is a fundamental legal tenet in societies governed by the rule of law. The violation of this principle is not encountered. So, the recent judgment marks the 16th violation ruling by the court in its history. So, it's very rare. The incrimination of hundreds of thousands of people in contravention of this principle is profoundly shocking. So witnessing such a grave systemic violation, in my view, a source of shame for all Europeans. So we all let the Turkish government to do this. It's harsh.
It's it's a very, very significant judgment. And the fact that the court actually found a violation to Article 7, it sets quite a bit of precedent for the following cases as well.
Yes, unfortunately, it's that. Yes.
But that is great. Thank you so much for your insights. It was a very insightful interview. Thank you so much for your answers. And of course, agreeing to participate to this.
And thank you. Thank you for inviting me, having me. Thank you, Maria.
Of course. Goodbye.